Tom Devine is the Legislative Director of the Government Accountability Project, a leading organization representing the rights of whistleblowers. Mr. Devine has written extensively about whistleblower laws and has worked with whistleblowers for over 2 decades. Mr. Devine received a BA from Georgetown University, his law degree from Antioch School of Law.
Thank you. I'd like to begin by responding to a few of the previous speaker's points. He said that as a general view, whistleblower laws that protect complaints about anything would cause chaos. Well, of course that's true. Whistleblower laws protect those who exercise free speech rights to challenge abuses of power that betray the public trust. Let's be clear who we're talking about. Second, the gentleman said the SOX law is very favorable on paper. Well, it is on paper. That's the problem. The Achilles heel is administration and due process rights to enforce those paper rights. Let me give you a few examples of the Achilles heels. The first one is the Occupational Safety and Health Administration. Just to illustrate the quality of work there, due to the volume of complaints, GAP has had to develop a manual on how whistleblowers can find their cases when OSHA loses them. During the investigation, the agency regularly engages in double standards on the right to counsel, access to evidence, and the opportunity to rebut the other side's arguments. Then there's the other end of the administrative process, the Appeals Review Board. That reflects the legal system's lowest common denominator for appellate review. The members are minor league political appointees with 1-year terms, frequently without any subject matter expertise, who don't even move to Washington because they view their jobs as part-time. They haven't returned any corporate whistleblower to the job since Sarbanes-Oxley was passed in 2002. GAP has helped about 4,000 people since I came there in 1979, and every day we're called on by whistleblowers to answer questions about the facts of life with their rights. My testimony has a baker's dozen examples of those questions, and the answers we must give if we're going to be honest. They're based on the 3-part Department of Labor process that's been highlighted today. Let me give you a few examples. First, who do these laws protect? Well, in any given industry, potentially any employee or almost no one. It is like a road with more potholes than pavement. The laws are generally tucked into specific laws such as environmental or occupational safety statutes. So any corporation potentially could violate those laws. So any corporate employee potentially has rights about some things. But about other more significant problems, they have none. For example, at a meatpacking plant, you can be protected for disclosing the runoff of fecally contaminated water into the river, but not for selling fecally contaminated meat or poultry that arrives on our family's dinner tables. Or at pharmaceutical companies, you have rights if you challenge false statements to the shareholders, but not false statements to the government or the public for potentially lethal drugs like Vioxx, which killed 50,000 Americans from unnecessary heart attacks. Well, second, what am I protected for blowing the whistle against? Most laws protect exposure of illegality or other actions to carry out the purposes of a statute. But Sarbanes-Oxley eliminated that catch-all. So now the game is, how illegal is illegal enough? Some of the early decisions have made a few factors to answer that. You must first prove that, 1, the fraud itself is material, or about sometimes 1% of annual revenues. Second, that the government actually will act to punish the misconduct. And third, that the punishment will have a direct and specific impact on shareholders that lowers stock value. There's no protection for, quote, speculation, also known as warnings. Well, so much for knowing where you stand. Third, if I speak out, when will I become a legally recognized whistleblower? Well, that's a good question. It used to be that challenging corporate misconduct internally triggered rights as an essential preliminary step for responsible government disclosures. But under some recent decisions, that coverage has been disqualified, which forces employees to ignore their employers and contact the government behind the company's back, or else risk waiving their rights. That's not a healthy system. Well, how long do I have to act on my rights? Generally 30 to 90 days. There is a doctrine called equitable tolling, but don't count on it. In one case, DOL extended the deadline to a year. In another, Mr. Henry Emanuel, they threw out his case for being 43 days late. Well, how long is this going to take? On paper, 30 to 90 days, but in our experience, 2 to 3 years commonly, up to 14 years, 6 years not uncommon. And to illustrate, it took labor 4.5 years to tell Mr. Emanuel he was too late for his rights by filing 43 days after a 30-day deadline. Madam Chair, at GAP, we say that whistleblower laws can be divided into those that create a free speech cardboard shield or a metal shield. Anyone going into battle with a cardboard shield, no matter how impressively it's painted, is going to die. While conflict is always dangerous, with a metal shield, you have a fighting chance to win. The current system is broken. It's a cardboard shield. It's time to get this right, and thank you for starting that process.
Thank you. Now, you can't do that.